Welcome to the Civil Rights Compliance Workshop, presented by the New Mexico Crime Victims Reparation Commission, Grants Department. We're excited to have you join us today to learn more about civil rights. As a recipient of federal funding, your agency is mandated to comply with various civil rights standards and reporting requirements. This workshop will cover your civil rights obligations as a subgrantee, applicable civil rights laws, anti-discrimination regulations, and civil rights monitoring and compliance. You can download the presentation slides using the link in the description, and remember to submit your agency's annual civil rights compliance checklist as a record of your attendance to cvrc.grants@cvrc.nm.gov. CVRC requires the authorized individual and all funded staff to participate in this workshop. The United States Department of Justice, Office for Civil Rights, enforces the civil rights laws you see on your screen now. By accepting federal financial assistance, you've agreed to comply with each of these laws. Please remember that the entire agency is subject to these civil rights obligations, not just the federally funded staff members or programs. Let's review each of these laws now. Title VI of the Civil Rights Act prohibits federally funded programs like activities invoiced to your VOCA or VAWA grants, from excluding, denying, or discriminating against participants on the basis of race, color, or national origin. The Victims of Crime Act, or VOCA, also prohibits discrimination in participation of funded programs on the grounds of race, color, or national origin, but also explicitly protects against discrimination in employment and adds religion, disability, and sex as protected classes. When the Violence Against Women Act, or VAWA, was reauthorized in 2013, the Act added further protections against discrimination on the actual or perceived gender identity, sexual orientation, and previously mentioned protected classes. VAWA only permits funded activities to be segregated by sex or specific to a sex if segregation is necessary to the essential operation of the program. If providing sex-specific programming, the agency must provide comparable services to excluded individuals. Section 504 of the Rehabilitation Act protects disabled individuals and individuals with physical and mental disabilities that substantially limit one or more life activities, have a record of impairment, or are regarded as having an impairment. It also requires large agencies and agencies receiving high levels of federal funding to have a 504 compliance coordinator, adopt grievance procedures, and notify that it does not discriminate on the basis of disability. In 1990, the Americans with Disabilities Act, or ADA, further enhanced protections for disabled individuals accessing federally funded programs. It protects disabled individuals and individuals with physical or mental disabilities. This includes the deaf and hard of hearing, who are also protected under the limited English proficiency requirements. The Age Discrimination Act protects individuals from being discriminated against or denied services based upon age. Title IX of the Educational Amendment of 1972 bans gender discrimination in federally funded educational institutions. The U.S. Department of Justice regulations on the equal treatment for faith-based organizations prohibits funders like CVRC from discriminating against religious organizations in the administration of federal funds, while also protecting participants from religious discrimination in funded programs. In summary, CVRC subrecipients cannot discriminate against individuals based on race, color, national origin, which includes language, religion, including religious practice, religious belief, and sincerely held moral or ethical beliefs, sex, gender identity, sexual orientation, age, or disability. Let's dive into that last one a little more. DOJ-funded recipients must provide reasonable accommodations for known physical or mental limitations of an otherwise qualified disabled individual, unless a recipient can demonstrate that providing an accommodation would be an undue hardship or would fundamentally alter the service or activity. Every case requires individualized analysis. Individuals with disabilities are not a homogeneous group, including those who share the same disability. Let's put your knowledge to the test. Can a VOCA-funded domestic violence shelter have a blanket policy that residents cannot take any prescribed psychotropic medication while staying at the shelter? Is this acceptable? No. By having a blanket exclusionary policy, the shelter has discriminated against individuals who may have a mental disability that may be controlled by medication. An individualized assessment must be done for each accommodation request. Any program or activity that receives financial assistance from the DOJ is subject to these civil rights laws. All of the operations of an agency receiving federal financial assistance, such as the entire department or office within a state or local government, must comply. If a state agency receives federal funding and subawards the funding to local community-based organizations, all of the operations of the state agency have civil rights obligations, along with the operations of the local community-based organizations. If a rape crisis center receives federal funds and uses those funds to operate a particular program, all of the activities at the center are covered, not just the federally funded programs. If a project of a county sheriff's department receives federal funds, the entire sheriff's department is covered, but not the other departments in the county. The Equal Employment Opportunity Program, or EEOP, is required by the anti-discrimination provision of the Omnibus Crime Control and Safe Streets Act of 1968. Recipients of Justice Department funding must create and implement an EEOP unless specifically exempted. The components of an EEOP include 1. The Equal Employment Opportunity Program, 2. Written Equal Employment Plan, 3. Verification Form, and 4. Utilization Report. Entities must submit an EEOP if they receive funding subject to civil rights provision of the Safe Streets Act, and the recipient is a state or local government agency or a private entity, and the recipient has 50 or more employees, and the recipient has received a single award of at least $25,000. An entity does not need to submit an EEOP if it is a medical or healthcare institution, or an educational institution, or an Indian tribe, or a nonprofit organization. The DOJ has an EEOP report builder tool with step-by-step instructions to create your report and verification form. Navigate to the URL on the screen to access the tool. The following are examples of civil rights violations. A funded domestic violence clinic that has a blanket policy of only providing services to female victims of domestic violence and not victims of other genders. Male employees at a funded detention center sexually harass female occupants. A culturally based sexual assault program primarily designed to provide services to Latina individuals turns away individuals of other ethnicities seeking services. The Office for Civil Rights monitors CVRC too. OCR verifies that grantees with 50 or more employees or more than $25,000 in DOJ funds have a 504 coordinator. Grantees are also required to have a grievance policy, limited English proficiency policy, and a policy that all individuals have the right to participate in programs regardless of race, color, national origin, sex, religion, disability, and age. CVRC must have written procedures for employees to follow when a complaint is received alleging discrimination from clients, customers, program participants, or consumers of CVRC or of a CVRC subgrantee receiving DOJ funding. That means all of these conditions are also passed down to subgrantees and can be found in your contract. CVRC is required to monitor your organization's civil rights compliance by looking at your policies and procedures, such as who do you report civil rights violations to? How do you train staff and volunteers on civil rights? How do you inform clients about filing a grievance? When you receive a complaint, are you forwarding it to the EEOC, the Office for Civil Rights, and CVRC? CVRC has clear policies and procedures that explain how an individual can complain directly to our office, how we will refer the complaint, and how we will acknowledge and train on the requirements related to the complaint. CVRC will notify employees or beneficiaries when the complaint is forwarded to EEOC and OCR. CVRC's Civil Rights Policy is available upon request, or it can be downloaded at www.cvrc.nm.gov. As part of the Grant Management Webinar Survey, subgrantees are required to acknowledge receipt of this policy. CVRC's written complaint procedures include our designated compliance coordinator, CVRC Director Frank Zubia, how to file a complaint, how employees will handle complaints, whether written acknowledgement will be provided, how the complaint will be referred, and how CVRC staff will be trained on requirements. Victims and employees of agencies receiving federal funds have a right to file a complaint directly to CVRC, so subrecipients must provide victims and employees with grievance policies that include CVRC contact information. Submit formal complaints to CVRC in writing to CVRC Director Frank Zubia by email, mail it to the office, or hand deliver it to the office at 6200 Uptown Boulevard in Albuquerque. Please visit the CVRC website for more resources, including the CVRC Civil Rights Policy, Civil Rights Compliance Checklist, and these presentation slides. You can find additional video trainings or file a civil rights complaint on the Office for Civil Rights website. We thank all of you for the important work you do in supporting New Mexico's victims of violent crime, and we wish you a successful year.